Welcome to Bloomberg Law. I'm Pacchia. On Friday, President Obama is scheduled to sign the America Invents Act. The legislation is nearly a decade in the making and has been called the most sweeping patent reform in nearly half a century. However, support from intellectual property experts and the patent bar has been mixed. Joining me now from San Francisco to discuss the changes is Stuart Meyer. Stuart is a partner at the law firm Fenwick West. Welcome.
Hi there, Lee.
So we're moving from a first to invent system to a first to file system. What changes are we seeing in this bill?
Well, the primary thing is that the United States has stood pretty much alone in the world in having this system where the first person who actually invents something gets the right to a patent, regardless of when he or she gets to the patent office. And of course now it seems like a major change in that it's the first inventor, still has to be someone who believes they invented the thing that's to be patented, who gets to the patent office, who gets priority. Mm-hmm. It's actually not as much of a change, though, as it seems. And there are many reasons for that, the most important of which is that lots of inventors care about getting protection throughout the world, not just in the U.S., and so they've had to think about the provisions, first to file provisions, in the rest of the world for a long time now anyway.
So this new system is going to bring us in line with pretty much the way things work in other countries around the world. What are the major pros and cons for being on the first to file system?
Sure. Well, one of the cons is, and it's often cited, that there are detriments for smaller companies who don't have the resources to be really up to speed and have a patent attorney on speed dial so that they can get an invention reduced to a patent application right away and get it on file immediately. That's been the primary criticism of this system. Actually, Senator Leahy, one of the sponsors of the bill, in May went through a lengthy recitation of the reasons why that actually isn't the case, why small inventors are just as well suited to get protection as large companies are, and how they need to be mindful of this anyway, as I just mentioned, in order to be not subject to other people's patents in the rest of the world. They need to be doing these things anyway. One of the advantages of a first-to-file system is that it gets rid of a tremendous amount of complexity. There was a fairly complicated procedure that was used in the U.S. to figure out who was actually the first inventor when the second person to file claimed that they were the first one to invent. And a lot of evidence had to be provided in fairly arcane ways to make that happen. Many small inventors are not about to keep records of the way that they invent and both conceive and reduce to practice their inventions in a way that's going to provide good evidence of that for those interference proceedings anyway. So the whole procedure of determining through an interference proceeding in the patent office who the first inventor really was, that's all going away now.
I see. So what are some of the other changes that are coming up in the bill? I understand that the funding for the patent office is going to change. How so?
It is. There's a revolving fund that's being set up. The idea behind it is to try to ensure that the Patent Office gets to keep more of the fees that it collects for its services. Many commentators are saying that this is significantly watered down from the original thought, which was to guarantee that the Patent and Trademark Office can be truly self-funding, in that if it needs to increase fees, it does so, but it gets to keep all that money so that it can hire enough examiners to keep down the patent examination backlog that's been sort of a plague of the system for many years. The final version of the bill, as it's heading to President Obama, however, has provision in there that many people say pays lip service to that concept, but doesn't actually require Congress to let the PTO keep all of its fees. And so it's going to have to be honored more in the spirit than by the letter of the current form of the law.
I think it's an understatement to say that we've seen an awful lot of patent enforcement litigation over the last couple of years. What effect, net, is this bill going to have on litigation going forward in the patent arena?
Well, there are going to be many different effects. The initial effect is that there is going to be a real quick sort of burst of lawsuits before the bill is signed into law on Friday. And we've already seen a little bit of that. A lot of dispute resolution is going to be shifting from the courts over to the patent office itself, because there are a number of new procedures that are in place to make it easier for people who are concerned that a patent might be improvidently granted to go ahead and challenge that patent with the patent office after the grant. And so I think we're going to see a much greater use of those new procedures than, well, obviously than before, because some of them are brand new, but some of them are just modifications to existing procedures as well. So I think we'll see a lot more action in the Patent and Trademark Office for resolving patent disputes.
Yeah, I want to talk about that short-term increase briefly. Bloomberg News is reporting that patent enforcement suits have increased tenfold in just the last 2 weeks. What is causing that trend? That's an enormous jump from my perspective.
Well, sure. There's a provision in the new law that says that a patentee cannot just gather together a whole group of accused infringers and sue them with the convenience of one lawsuit in court. There has to be a connection between the defendants that's more than just you all infringe this same patent. So that has been a fairly common technique that plaintiffs have used to reduce their costs and gain some leverage, essentially by suing an entire segment of an industry with just one action.
Now, why do you think Congress included this provision?
Well, it was clearly intended to cut down on that practice, which is primarily not used by one competitor against other competitors, but by companies that are not necessarily practicing the invention, but just are holding the patent rights. And it's a convenient way to assert those. And what some have claimed is try to impose a private tax on industry by doing that. So that's the impetus behind those changes.
Now, when we're talking about these non-practicing entities, we're also talking about, in some cases, so-called patent trolls, to use a pejorative term?
That's a term that's used by many, yes.
Okay. Now, do you expect this to be a short-term bump in litigation, or do you expect this to continue after the law is signed on Friday?
Well, there's no reason for it to continue, so it is just going to be a short-term bump. What's interesting, though, is whether the practice is really going to end, because courts have tremendous discretion in what they're allowed to do for the sake of judicial economy. So it may be that the plaintiffs who would have wanted to bring in multiple defendants, they just will go ahead and file using essentially the same form of complaint, multiple complaints on the same day in the same court. And then one of the obligations in court is to name all the related cases that exist. And many judges, for the sake of efficiency, will say, well, why don't we do a whole bunch of things in these cases together anyway? So it may be the courts that end up putting the cases back together and resulting in at least something fairly close to what we have right now.
So net, this doesn't necessarily mean that patent trolls are just going to go away. They'll still exist.
Oh, that's for sure.
Okay. Now, this bill took years to put together, yet many people are saying that this bill failed to address some of the real problems in the system. Do you agree? And if so, what should have been done in your opinion?
Well, I don't think it's anybody's fault. The fact is that there are a lot of people who have said for a long, long time that the patent system is broken, but they said that from very, very different perspectives. And trying to figure out how to fix that system results in very, very different answers depending on who's suggesting the fixes. So the initial agreement was that there were all kinds of problems, but determining how to come up with a solution was tough. You know, the whole point of intellectual property law and patent law is a balance of rights between society in general and the inventors. And different constituencies have very, very different thoughts on what's important. So getting the balance right is extraordinarily difficult. Congress has a tough time with it. The courts have a tough time implementing what Congress has done by interpreting the laws. And it's just a tough thing to do. So I don't suggest that anybody made a mistake or did something wrong. It did fall short of a lot of expectations, though. If you were to have had a Q&A with somebody 5 or 10 years ago about what should be addressed in our patent system, in addition to the first to file and the patent fee diversion issues that we've talked about, they would have talked about overhauling the overall damages approach that our system uses, the approach to granting injunctions in patent cases, the types of inventions that were even eligible for patent protection.
Right.
Those all would have been issues to include in patent reform. Since it took so long, courts have done their best to work with the current statute to address some of those issues, but the fundamental underlying question marks that were unclear from our existing statutory scheme, well, that hasn't really changed very much as a result of this effort at patent reform.
Right. What about the movement to reimpose traditional rules on what can and cannot be patented? Is that issue just dead on arrival now, or is that something you expect to be taken up in the future?
Well, if you mean by congressional action, it's probably going to be a long, long time before we see Congress have the stomach to sort of dive back into these waters and address some of the more difficult issues. There are a lot of cases right now. There was a big case last year called the Bilski case out of the Supreme Court that helped to address what the current statutory scheme means for the types of method inventions that are patentable. And there are some more cases in its wake that are coming up. There's one that's percolating right back through the Supreme Court right now and will be decided by June of next year. So the courts are dealing with this issue right now. The only thing that Congress really did in the current effort at patent reform was to make a couple of mentions of limitations that are going to be imposed on business method patents and to distinguish them from the more sort of technological inventions that we're all used to seeing. And some will undoubtedly read that as Congress accepting the fact that there are and should be business method patents, while others will say, well, they didn't really address it full on, so that's still an entirely open issue.
Stuart, we've also been seeing so many stories in the M&A space about how transactions are being spurred by patent valuations. Is this particular bill going to have any effect on the mergers and acquisitions landscape?
Well, it is, of course, but we don't exactly know how yet. And the reason for that is that patents are very, very important for so many sectors of our economy and so many industry niches that, of course, a major part of the due diligence that's undertaken before a major transaction has to do with looking at the strength of the patents and the likelihood that they can be enforced against competitors. The problem that we have is that so much of what's in the new act has to do with regulations that the Patent Office needs to put into place, some of which won't come online for the next 18 months. And the devil is really in the details here, depending on how the regulations are written, depending on exactly what sort of provisions are required. It's going to be difficult to see whether it ends up strengthening or weakening patents to a degree that would actually impact their value.
All right, let's leave it there for now. Stuart, thanks so much for joining us today.
Thank you, Lee.
That's Stuart Meyer. He's a partner at the law firm Fenwick West. If you'd like to learn more about the issues we discussed today, go check out our intellectual property law report. It's available on BloombergLaw.com. I'm Pacchia. Thanks for watching.